Okay, this is our unboxing video for the Supreme Court's decision in Horne against the USDA. But before we begin, I think I'm going to indulge in some healthy snacking. Oh yeah, they were right. 8 justices can't be wrong. These are just great. Let's see here. Okay, title page, syllabus, who cares? Second page, syllabus, more syllabus, we don't care either. Third page, more syllabus. Okay, here we go. Physically set aside. Okay, game over, Horne's win. This is going to be another one of those physical occupation cases, that fetish cases, what I refer to it as, like Kaiser-Etna, Loretto, and now Horne. And the court poses the question. The question is whether the Takings Clause of the Fifth Amendment bars the government from imposing such a demand on the growers without compensation. So now we know the remedy. It's invalidation of the Government Act, which was, I thought, pretty much decided the first time the Supreme Court took this case, where the court said that just compensation in the Court of Federal Claims isn't a property owner's only remedy. Good, it's confirmed. Background. The court, USDA, takes title to 47% of the Horne's yearly raisin crop. Again, that physical takings fetish emerges, and we see that the court agrees with the Hornes, a point on which the government conceded, even though it ultimately argued that it was only title and that the Hornes maintained a potential beneficial interest in the raisins, therefore it wasn't an actual physical occupation. Okay, most interesting thing on this page, it's the bottom here onto the next, where the government tried to characterize this as a mere use restriction and a condition in a land use permit. You want to play in the raisin market, this is the price of the ticket. And I wonder what this stuff says about things like affordable housing requirements, an issue that was recently decided by the California Supreme Court in the San Jose case. That court held the city's requirement that builders of new homes set aside a certain percentage of their crop to sell at affordable levels. And remember, this is Silicon Valley, so their version of affordable probably looks like luxury to the rest of us. And that isn't an exaction because it doesn't require the developer to actually turn anything over to the government in return for the permission to build. Title wasn't required to be turned over, and no physical occupation, so says the California Supreme Court, therefore no exaction. A cert petition is almost sure to follow, so the Horne case will come into play, I think, relatively quickly. And here's a pro tip for all you appellate lawyers. When the court tracks your questions presented and uses the opinion simply to answer your questions seriatim, you know you're doing a good job. So hats off to the petitioner's counsel, and here the majority opinion does just that. It literally cuts and pastes the questions presented, then answers them one at a time. It's a sign of great appellate advocacy, or maybe lazy clerks up at the Supreme Court office. Let's see. Section 1 of the opinion, 8 justices agree. The opinion disposes, I think, of the easiest issue in the case, which is whether the Takings Clause protects personal property as much as it protects land. The Ninth Circuit said no, and cited Lucas. 8 justices said yes, it is protected in the same way. Magna Carta said it was. Some guy with the cool name of St. George Tucker, right there, said the Takings Clause probably was adopted in response to the arbitrary and oppressive mode of obtaining supplies for the Army. And I was looking all over for it, but I couldn't find it a Third Amendment citation. Well, okay, that's interesting. Pennsylvania Coal expanded protections of the Takings Clause by going beyond the previous understanding that raisins or Takings Clause only operated in cases of direct appropriation. I'll save that one to the memory banks. I thought it happened earlier than Penn Coal, but hey, they're the Supreme Court. Penn Central, another pencil, is still the default test for regulatory takings. And what about that Lucas language that the Ninth Circuit relied on? Regulatory takings, said the court, so it's different. Lucas wasn't a physical take case, but a regulatory wipeout, so you can't use the same language and transport it between different types of cases. The reserve requirement imposed by the Raisin Committee is a clear physical taking. Brief writers have always told me that I shouldn't use the word clear in my writing, because if it's clear, you don't need to say so. Well, it's good to be the judge, and they get to say so. Alrighty here. Next, Again, the physical things. A regulation can depress the value of your property pretty severely without it being a taking. But when the government physically takes something, that's different. This leaves us lawyers doing what we've always done in these type of cases with property advocates, trying their darndest to find the holy grail in takings law of the physical take, because after that, smooth sailing, while police power hawks say, this is nothing but a regulation, and you apply the rational basis, or as I call it, the no basis test, or the no scrutiny test. Okay, next page. The chief junks the dissent's claim that this isn't a total wipeout of the value of the raisins. Never mind that stuff about title. And hey, government said maybe, possibly, perhaps there's a chance that the Hornes might get something back in the future after all. After all those admin costs are taken out of running the program or factored in, they might get something back. They're entitled to that under the law. Well, that's not good enough, said the court, and this is a quote, "A contingent interest of indeterminate value remaining doesn't lessen the blow of a physical grab of the raisins." Speaking of which, it's time to grab another healthy snack. These are good. Okay, next. Eagle feathers aren't raisins. Got it. If the government prohibits sale of feathers, you can still do other things with them. But the raisins, not these raisins necessarily, but the Horne's raisins, the Hornes don't have the right to do anything else with it. Got that. Okay, good. And the raisins, they're not shopping centers either. The Prune Yard Center voluntarily opened up its public its property to the public, and once it did that, it was hard for it to say that it could exclude some of the public because what they wanted to talk about. Raisins, prunes, okay, we got that. Speaking of which, what about the argument that the Hornes didn't need to grow raisins, or they could have done something else with their raisins, like make wine? Yeah, wine, we're down with that. But the court wasn't. Let them sell wine was the chief's snarky response, and we love judicial snark unless it's directed at us. And so what the chief said is, you can't make the ticket to admission to the raisin market conditional on giving up some of your product. And to us, again, that sounds like rent control and affordable housing. Maybe, maybe not. As I mentioned earlier, we'll see. On raisins, they're not pesticides either. They're dangerous, while raisins are, as the court said, and here's the money quote of the day, a healthy snack. So in the Monsanto case, it was okay for the government to condition Monsanto being allowed to market pesticides on its surrendering of trade secrets, because otherwise Monsanto might not be able to sell those pesticides. But raisins aren't dangerous. In fact, they're delicious. Yum. Okay. And raisins aren't oysters either. Check. The Leonard case. Oysters are wild animals owned by the states, while raisins are a healthy snack. Raisins grown on your private land by your hands are much different than oysters cultivated on state property. And to us, that's kind of interesting, because the oyster issue was raised more at oral argument than in the briefs. And the distinction that the chief is making, I wonder what that might mean for the public trust doctrine in wild animals and the like. Did the state really own the oysters in the Leonard case? I don't recall. It's been a couple of months since I've read it. And I think it's time to go pick that case up again and see what the court in that case really said. Well, and I think here we get to the disagreement, the real disagreement. Clear off some of those healthy snacks. The remedy. 3 justices want to send the case back to the Ninth Circuit to calculate just compensation, to see if that court can't blow the case yet again, and Professor McConnell can get a trifecta of Supreme Court arguments in this case. So no need, said the chief. 3 generations of imbeciles are enough. Oops, wrong case, sorry. You Buck versus Bell fans, everyone else, send your complaint letters to rht@hawaiilawyer.com. Seriously, though, the chief and the majority concluded that the just compensation in this case was already calculated, which was the amount of the fines imposed by USDA, which was supposedly based on the market value of the raisins. Now, we think that's nice, Your Honor, but it's too hard. What matters for this, in the takings defense in this case, is that the regulation itself didn't provide for compensation. It doesn't matter whether they got it or whether they could go get it. There was never any need to calculate compensation in this case, just determine that the regulation didn't provide any, the government didn't offer any, and the Hornes didn't get any. You decided that, we thought, on the first go-round when you said that they could raise their takings defense in the district court and that they didn't need to pay the fine and then go back as just comp in a court of federal claims action. Well, so we're done. Ninth Circuit reversed, case over. Oh, well, maybe not quite. Special benefits. We're going to have to read Justice Breyer's thoughts on that, since he was the lead guy in oral arguments pressing the free rider argument that the court addresses in the last couple of pages. But other than that, we'll do that in a minute, but other than that, case over, Horne's win. But first, before we do that, before we get to that, Justice Thomas had a short concurrence for the purpose, we presume, only of making the required raisin pun, where he says, to the extent that the committee is not taking the raisins for public use, having the Court of Appeals calculate just compensation in this case would be fruitless exercise. Well, well played, Your Honor, well played, don't forget to tip your waitresses. Okay. On to Justice Breyer. His beef was with the lack of remand. He and the two others, Justices Ginsburg and Kagan, thought that the case should be sent back down to calculate whether the Hornes received just compensation, since the takings clause says, no takings without just compensation. So maybe they were compensated by, having the market price of their non-taken raisins raised, for example. And where did this argument come from? Did the government push hard for it? Was it in the cert petition, questions presented? Did the Ninth Circuit decide it? Well, no. According to Justice Breyer, it was barely touched on in the briefs. So he Posnered it. He said, the case law I have found. Whoa, whoa, whoa. Okay, okay, folks, here's why we think that's dangerous. Over the next couple of pages, Attorney Breyer, Justice Breyer, relies on the benefits rule, what he calls the benefits rule, to support his point that when looked at overall, the Hornes might be better off in the program than outside it. You takings guys remember the benefits rule. When a taking increases the value of the property, that has to be taken into account. So if a new road takes property and that road creates access to the remaining land that wasn't there before, maybe the land is worth more in its after condition than it is in its before condition. But this is not some general rule, and it's a special benefits rule applicable only in rare circumstances. Three things have to take place. First, it's applicable only to partial takes, not total takes, where the benefits that go to the remainder parcel are specific to the remainder parcel and are not something shared with the public at large, which is kind of problematic here. And three, the special benefits may only be set off against the remainder value and not against the value of the property actually taken. So at least that's true in my jurisdiction, and your mileage may vary. So, I think the bottom line is that Justice Breyer really is out in left field with this one and is in effect bootstrapping a narrow just compensation doctrine into the question of whether there's been a taking at all, even in a case of a physical occupation, which really just kind of seems wrong to me. It sounds more like regulatory just compensation doctrine and not regulatory takings, because takings is concerned with impact on the property and not value to the taker. And when there's been a physical taking, you really don't care how the remainder has been benefited at all, I thought. And I think this highlights the dangers of judges going off on their own, doing their own research on theories that weren't developed below or argued by the parties. Because now the rest of us, we're going to have to deal with it with nobody having presented the actual doctrine to Justice Breyer to clear this up. And his dicta in this dissent is going to be thrown in our faces like it was handed down from Mount Sinai. Okay, well, so much for his concurrence and dissent. On to Lone Wolf, Justice Sotomayor. She goes off on her own yet again in these type of cases, and for the latest example before this, see her solo dissent in the Rails to Trails case, Brandt against the USA. And here she says there's been no taking at all because the USDA didn't take all of the Horne's rights in their raisins. And so we searched through it and tried to find, well, what rights do they have left in those raisins that were turned over to the government? She says, well, look at the contingent remainder. Maybe what's left over, that potential future amount that they might get back Well, they're like eagle feathers, you know, you've got some other use. They're like oysters, they're like pesticides. And even down here, she gets to Ye against City of Escondido. They're like mobile homes, you know, we own the market, and you know, you guys who actually make things, you just kind of live in it. So if you want to play in our rules, you have to do stuff you have to give up things. And so she finishes with this gem. The virtue, she says, of Loretto was its clarity. But Horne has muddied the waters. Problem is, the way that Justice Sotomayor reads Loretto, there really wasn't anything there to begin with, because as she sees it, Loretto's physical occupation rule only applies if the occupation destroys the value of the property so occupied, as opposed to simply damages it to a great extent. Which is just another way, I think, of bootstrapping the Penn Central ad hoc economic test into physical takings doctrine, and that really doesn't get you anywhere. So now I think you know why no one else has joined her dissent. Well, we hope you've enjoyed this. We certainly have. And now we're going to go have some more healthful, tasty snacks.